Said I remember when we used to sit in the Madlanga Commission in Tshwane, observing the hypocrites, as they say, where is the proof? No Mzansi, no crime. Mkhwanazi said, no Mzansi, no crime. Welcome to another episode of The Dissection. There has been an interesting phenomenon that I observed in the media since General Mkhwanazi finished his testimony on Friday. This idea, this argument that he has not presented evidence, and it is primarily being made by people who don't have legal training or a legal background. First, I saw it on News 24, and I think that was on Saturday. Then on Sunday, day of this recording, I also saw Sunday Times writing an article making the same argument using the exact same words. Where is the evidence? Where is the evidence? So from the onset, I want to make it clear that General Mkhwanazi has actually presented evidence. There are various forms of evidence that he has presented, and I'm going to go through them in this episode and actually cover what evidence is and what the textbooks, the case law, say about what evidence is. So the first form of evidence that we must be aware that General Mkhwanazi has presented is oral evidence. Oral evidence. Oral evidence is the first-hand account of events provided by testimony. General Mkhwanazi has first-hand experience of various facts in issue. Most forms and categories of evidence are admitted at a trial by a witness giving oral evidence through an examination in chief. This is what we have seen happening from Wednesday to Friday. Oral evidence then allows the court to evaluate a witness's demeanor, their mendacity, and to draw inferences about the credibility of the witness. And the case law for this is S versus Adendorf. And I'm not going to mention a lot of case law for this. If you wanted, maybe I'll put it in the comment section for those who want to research further. Hey, check if you've subscribed or not. Check. Many people are watching the videos, but they haven't subscribed yet. About 70% of the people watching the videos are not subscribers. And that's Hosh behavior. Subscribe today. Subscribe today. I'm making it free 99. You just press the button, press the notifications so that you don't miss an episode, and you're in. It's that easy. Not subscribing is Hosh behavior. We're getting closer and closer to 100,000 subscribers. So let's push. Let's cross that line. It's just a symbolic line. You know, I try to make episodes at the same level of consistency, whether it's 1,000 people watching or it's 600 people watching or 500 subscribers. That don't matter to me. I try to bring the heat because you matter. One viewer matters. I have to reach you and provide this service to you so that you can think through all of these issues for yourself. So I've already said on other platforms and in other interviews that or other episodes rather, that General Mkhwanazi, in my view, when he gave testimony in respect to demeanor and truthfulness, was robust and credible. I view him to be a credible witness. His composure, he didn't seem like he was lying. He didn't seem like he was being evasive. He was addressing the questions directly, fully, and even where he could not necessarily corroborate what he had said, gave us a clear indication of who would come and corroborate that, what they would actually corroborate, and what the effects of that corroboration would be. What's curious about the media moves and the narratives that I've seen is that there's not been a lot of contention about the truth of what he said. For example, Fadel Adams, the member of parliament who got top secret documents, he says, on his desk under his door, he didn't deny that he got the documents and that those documents were not lawfully in his possession. He didn't deny that. He just said, I'm new to parliament. I got these things under my door. I wanted to get to the bottom of what's going on. Realistically, he wasn't supposed to read those documents. But rationally, most people will read documents that say top secret that are given to them, right? Just because human nature, curiosity is the thing that killed the Vusi Matlala, right? So at the fundamental level, it is true that they got those documents. The argument that was used by Diane Kohler-Bannert is a technical argument because she says, I got these top secret documents, but When I got them, it was in between the election and the constitution of the new committee. So, and I saw them in the media, and then I just spoke about what I saw in the media. Who gave the documents to the media? You were in possession of the documents. You were the person who was speaking about the documents. It's inferable that you are the person who actually is the one who gave them to the media and then is now using the media as a cover for you actually now speaking about those documents. So nobody's contested the truthfulness. For instance, not only has he produced oral evidence, he has produced other forms of evidence. And now let's talk about documentary evidence. Documentary evidence is evidence by the way of a document. Everything that contains the written or pictorial proof of something. It includes any book, maps, plan, drawing, or photograph. For instance, he produced 3 letters that are significant to the discussions. 2 from prosecutors. One prosecutor was discussing an issue of concern about how Michael Puletao, the police officer, got bail while facing murder charges, being in a position to compromise those investigations and pose a threat to other police officers to the extent that those police officers had to get protection. The other letter that he got was from the KZN prosecutor, who was concerned about the status of the task team and how they would be working with the task team, indicating that they were not privy to some of the information that the Minister of Police would have had to make them privy of if the decision that he had taken was done in a thoughtful, thorough, robust manner, that decision to disband the task team. He's produced the letter which was delivered to the Minister of Police in 2022, the letter raising concerns about Sibiya and the corruption scandal involving Sibiya from Gauteng. Right? He produced evidence of the messages that he got from Brown Mkhwanazi. Evidence of those particular messages was not in dispute. He then showed us a message from Brown Mkhwanazi to Minister Senzo Mchunu. This is not just chit-chat. This is relevant and probative evidence, right? Electronic documentary evidence and documentary evidence in and of itself. He's produced that. Why are we getting a narrative or a question, where's the evidence, when the evidence has been produced? He himself is a witness to various events, and he is more than a regular witness, because we're looking at the testimony of a police officer with 33 years of experience, somebody who, when he was in the police roles, has operated in various spaces and places. When a police officer provides testimony, they are a form of expert in their field. He's not just a Nyaupe guy who was at a corner somewhere that people brought to Pretoria and said, tell us what you know about crime in Gauteng. No, he's also not a politician who was appointed to the role. This is a career police officer who has been involved in the oversight of some of these investigations and is therefore privy to information and can give us direct information about who said what and what was said to him. This is not just gossip on a radio show. This is evidence. Look, it looks like this will be a big topic that will be pushed on various platforms. This idea of what is and what isn't evidence. So I think let's talk about it, right? Let's talk about the law of evidence, right? So what I'm going to tell you now is from textbooks, such as this textbook here, Principles of Evidence. I had to go over it again. I have gone over it a few times because we've been talking about evidence a lot. I even had to go back into my trunks and stuff and find my law of evidence notes from Wits University, where I studied law. So some of these journalists have not done law. So let me now tell you what you need to know about the law. If you haven't watched my other episode, you're welcome to get a 101 here. So the first thing that we must talk about when talking about evidence is this. What are facts in issue and what are facts relevant to the facts in issue? So let me break that down. It's just jargon for now. Facts in issue are those facts which the party must prove in order to succeed. Facts in issue are those facts which the party must prove in order to succeed in their court process. The facts relevant to the facts in issue are those facts which tend to prove or disprove the facts in issue. So in a paternity case, the identity of the father is the fact in issue, right? Whether there was an intimate entanglement or the relationship is a fact relevant to the issue. The facts in issue are then determined by substantive law in general. Like the law will say, this is what you need to prove in order for this to happen, for that to happen. So in the paternity case, any evidence that can be adduced to show that these people bebejola or they were dating, that's going to be something that is a fact relevant to the issue. Then if someone saw them going into a room, heard some funny sounds and saw them coming out on a day which was 9 months before the birth of that particular individual, that can also be considered to be a fact relevant to the facts in issue. And then depending on how many of those you can bring together, you then prove or disprove the particular fact in issue. Okay? So like I said, the facts in issue are determined by substantive law. Substantive law is the branch of law that defines, creates, and regulates the rights and responsibilities of individuals and entities within a society. So different substantive laws apply differently, right? In terms of if we're talking about family law or other types of laws. So substantive law establishes what people are entitled to, rights, what they are obligated to do, duties, and what constitutes violations of those obligations, wrongs, or crimes, right? So there are certain things that must be proved in different types of law, right? Criminal law, there's a requirement that you must prove certain elements for an act to be considered a crime and to prove that beyond a reasonable doubt, okay? Now, there's something else called procedural law, and that is where the law of evidence falls in, because it explains how do we evaluate certain elements, and in particular here, how do we evaluate evidence. So now you know what are facts in issue, and you know what are facts that are relevant to the facts in issue. Now let's talk about evidence more directly. So, definition of evidence: any item or information presented to make the existence of a fact more or less probable in a legal proceeding. Any item or information that is presented to make the existence of a fact more or less probable in a legal proceeding is evidence. The means of furnishing proof of a fact in issue, that's also evidence. The means of furnishing proof of a fact in issue. Right? So you get it now. You understand what evidence is. A range of information may be considered when attempting to resolve a legal matter. This includes the following: written or computer-generated statements, oral or written statements, electronic mail exchanges, emails, photographs, tapes recordings, video recordings, the observations of eyewitnesses, the characteristics of physical objects. At the initial stage, before information has been formally admitted in legal proceedings, it cannot be in law labeled evidence. It can only be referred to at that point as potential evidence. The meaning of formally admitted evidence is this: only information relevant to the facts in issue is admissible as relevant, formal, admitted evidence with probative value. Let me do that again. The meaning of formally admitted evidence: only information relevant to the facts in issue is admissible as relevant, formal, admitted evidence with probative value. Now, there are different forms of evidence. They include the following: oral evidence, real evidence, documentary evidence, electronic evidence. Not all evidence is admissible in a court of law. There are various rules of evidence which determine the quality of evidence, the admissibility of the evidence, the relevance of the evidence. All of these are part of the law of evidence. The law of evidence is part of what is known as procedural law or adjective law. And procedural law provides the mechanisms and rules for which the system works for the enforcement of rights and duties, for the enforcement of the substantive law. Now, you need to be aware, having covered that part, there's also something that is known as evidentiary material, which includes the following: admissions, which can also be considered confessions, formal pleas. So admissions, confessions, formal pleas. Then there are presumptions. Then there's judicial notice. Now, confessions, I think it's very easy to understand, right? I make a plea deal. Maybe I admit to a variety of things, like what happened with Matlodi, when he admitted to his role in the VBS saga in a plea deal, right? That was an admission. Confession can be done before even a plea deal. You confess, you admit to certain things. That's relatively clear. Judicial notice is a legal rule where a judge accepts a fact as true without requiring formal evidence. because the fact is either so widely known and indisputable, this is what is known as a notorious fact, or can easily be confirmed in reliable sources, which is what is known as an ascertainable fact. So this doctrine of judicial notice allows courts to operate more efficiently by not needing to prove obvious or well-documented information, right? Because you don't have to prove on Wednesday, the 17th of such and such, this process started. How can you prove that it was Wednesday? We don't have to do that. We don't have to prove that the State Capture Commission started on a Wednesday in a presentation in court, because that is notorious at this particular point. So notorious facts, these are matters of common knowledge, like the basic facts of everyday life, right, that are beyond reasonable doubt. A judge can take judicial notice of these without any evidence. Then there are ascertainable facts, which are facts capable of verification. So other facts can be judicially noticed if they are easily and reliably ascertainable from authoritative sources, right? For example, a judge might take judicial notice of certain factual aspects of foreign law, certain things that have been reported on or have happened, right? They don't have to necessarily call in an expert witness to explain those things. So for the second category of facts, these ascertainable facts that I've been speaking about, the court may need to make an inquiry to confirm the fact's indisputable nature before accepting it as proven, right? So why did I just run through some of this stuff for you right now? There are some things that people are saying, where's the evidence? Where's the evidence? Sifunu bufakazi. What? Bufakazi for what? Look, at this point, it's well known that they are drug cartels operating in South Africa. It's well known that there's violent crime in El Dorado, in Westbury, in the Cape Flats, in Umlazi. You don't need to get a PhD professor to come and prove that. It's known that there are political killings in South Africa. It's known that the political killings task team has effected arrests and convictions. There are people serving jail time now. You don't need to he doesn't need to bring the judge who convicted the particular criminal to come and say, no, political killing task team, I salute those boys. No, that's not necessary, right? That is ascertainable, but it's also notoriously known at this particular moment. Who doesn't know that Babita Deokaran was killed for trying to block payments to the Tembisa hospital? Who doesn't know that? Who doesn't know the people who've been implicated in the Tembisa hospital scandal by SIU Investigations Asset Forfeiture Unit right now has seized assets of Morgan Maumela, Angwani Morgan Maumela, who is a connection of Benjani Chauke and a relative of President Ramaphosa. President Ramaphosa says he doesn't know him like that, but we have to give you the report about his connections. It's well known right now that DJ somebody was killed. DJ Vetis was killed. That Josie Banyoni, there was an attempted murder. Teboko Tobejane, there was an attempted murder. And I could go on. These things are well known. It's also known right now that Katiso Molefe is in prison waiting trial. Vusi Matlala is waiting trial. It's well known that the guns that were seized from the Cat Protection Services and other search and seizure operations have been implicated in 18 murders. That is known. Mkhwanazi doesn't have to come necessarily and prove that in his particular part of the testimony. It's known right now and ascertainable that Vusi Matlala and Hangwani Maumela were both registered as directors of Cat Protection Services. It's establishable, that stuff. It's CIPSI data that is there, and let me give it to you right now. It is known that Hangwani Maumela benefited to the tune of billions from the Gauteng Department of Health, in part through Tembisa Hospital. It is known that Vusi Matlala also benefited from this tender. It is known that Vusi Matlala got a massive contract of 360 million rands from the South African Police Service while he's not even worked in any space in the healthcare sector. He hasn't even provided massages at a gym. There's nothing that he has done that is healthcare related. He hasn't even given somebody Panado. This Hosh curry behavior has already been noted. It's known. It's ascertainable. General Mkhwanazi does not need to prove any of that. But what he did have to prove, he did prove. I could go on, but I think I've made my point. The strategy is not sound in law. It's not rational. It's not sound. It's not rational. What it suggests to me is that there's Hosh curry panic at the highest levels. Somewhere, somehow, somebody is panicking because some of these things cannot be explained away. Begitele cannot simply just say, I don't know Vusi Matlala. He can't say it. Mkhunu cannot say, I don't know Vusi Matlala. He can't say it. There's proof now. There's proof. And more is on the way. More is on the way. The 8 wonder on the way. Clear the way. I'm here to stay. That's what Jigga said. But Mkhwanazi has cleared the way. So this to me is confounding because we have to appreciate that somebody killed Babita. Somebody killed Aman Swat. They sprayed them with bullets. They sprayed them. AK-47s, TJ somebody. We saw it. Not the actual act, but the aftermath. 3 people sprayed with bullets. We saw what happened with the liquidators, sprayed with bullets. Somebody's spraying bullets in Gauteng. They're spraying them. They're getting rid of whistleblowers. Somebody is giving these children nyaupe. Somebody is stealing from the hospitals. These are the things that are at the heart of our conversation. For me, I sometimes wonder, why would you side or lean in a direction which seeks to create some pathway of absolution for people who have been implicated in these heinous acts? Acts that we know are destroying the fabric of South Africa. Why would you do any somersaults or any gymnastics in that direction? That's worrying to me. That's worrying to me. At this point, I heard O'Sullivan saying that he hasn't seen any evidence implicating Sibiya and he supports Sibiya. I'm like, but there's a letter from 2022 saying this man has to explain what he was doing. In Gauteng, money was spent irregularly. He's accused of getting 3 million in gratification. Paul O'Sullivan says he's a forensic investigator. I'm like, bruh, as a forensic investigator, you're not aware of this? You're not aware of all of the other allegations around this man? People have been raising concerns about the Meyiwa case, Mzilikazi's arrest back in 2010, 2011, whenever it was. I read that book. We saw the pictures. Smear's in the picture. I'm confused what's happening here. I'm really confused because I think this is an opportunity for the public to get answers and for this Hosh cartel to be held accountable. Why are you blocking any of this? Look, there are political calculations and dynamics as a result of this. But if these men and women, these Hosh mamas, the yellow bones with the yellow thighs, if they were conniving and acting as carnivores, right, on the body of South Africa, they have to face the consequences of what they did. Whether or not you like their politics or their coalition or the dynamics thereof, if people do what they do, they are responsible for that. You don't have to try to do gymnastics to protect them from any accountability. This is their day. Every dog has his day. Every cat has his day. Cat Matlala wets a manyala, and now it's his day. Let him see what he has to see. There can't be 10 lives. At some point, it's got to end. Tupac was not lying when he said, South Africa is a drama, a movie, a series. He wasn't. Because what we're seeing here cannot be explained outside of some weird script that somebody's trying to manufacture here. And they're trying to manufacture consent. They're trying to manufacture consent. Please get yourself this book. It's not easy to get this book, but please get yourself this book, Noam Chomsky, Edward S. Herman. It speaks about how the government sometimes works with the media to try to control public opinion. And they discuss the tactics upon which that is done. Propaganda tactics. You need to be aware. You need to be aware. Just be aware. So I want to end the episode, but I want to say, make up your own mind. Make up your own mind. Anyway, if you haven't subscribed, please subscribe. I'll catch you in the next one.